Welcome back. Today we are discussing a topic that is the skeleton of every nursing career in the state of Ohio. We are talking about nursing jurisprudence, specifically the laws and rules that tell you what you can do, what you can't do, and how to stay out of the Board of Nursing hearing room.
It sounds a bit dry to some, but Sarah, I always tell new grads, your license is a contract with the state. You wouldn't sign a 30-year mortgage without reading the fine print. So why would you practice nursing without knowing the Ohio Nurse Practice Act?
Exactly. And in Ohio, we have to start by understanding the two pillars of the law. We have the Ohio Revised Code, ORC, and the Ohio Administrative Code, OAC.
Can you break down the difference? Because they both sound like alphabet soup to most of us.
Think of the ORC 4723 as the skeleton. This is the law passed by the Ohio General Assembly, the actual politicians. It's the broad statutory authority that creates the Board of Nursing and defines the basic roles of RNs and LPNs.
And then the OAC 4723 is the muscle and skin.
Perfect analogy. The OAC 4723 consists of the rules. These are written by the Board of Nursing itself to fill in the details. While the legislature says nurses must be safe, the board uses the administrative code to define exactly what safe means, how you delegate, how you handle IVs, and what counts as a continuing education hour.
So the law gives the board the power, and the rules tell us how to use it. Today, we're going to walk through how these laws protect the public and, by extension, protect your license. Let's talk about the board itself. I think there's a common misconception that the Board of Nursing is there to protect the nurse.
That is probably the biggest myth in jurisprudence. The Board of Nursing's mission is public protection. They are a consumer protection agency. Their job is to ensure that every person in Ohio receiving nursing care is being treated by someone who is competent and ethical.
And who makes up this board? Is it just a group of nurses?
It's a 13-member group appointed by the governor. It includes 8 RNs, 4 LPNs, and 1 consumer member who represents the public interest.
I've heard you mention that they have quasi-judicial power. What does that mean in real-world terms?
It means they act like a mini court system. If you are accused of a violation, say a medication error or a documentation failure, the board has the authority to investigate, hold a hearing, and issue a final order. They can reprimand you, fine you up to $500 per violation, or, in extreme cases, suspend or revoke your license.
They aren't there to be your friend. They're there to be the referee of the profession. This is where the rubber meets the road. In Ohio, the law is very specific about the difference between an RN and an LPN. Sarah, how does the ORC define the RN's role?
The RN is defined as providing nursing care that requires specialized knowledge, judgment, and skill. The key word there is judgment. Only the RN can perform a comprehensive assessment, develop a nursing diagnosis, and create the plan of care. An RN's practice is considered independent in terms of nursing judgment.
And the LPN? Because in many hospitals, LPNs and RNs look like they're doing the same tasks.
Legally, they are worlds apart. An LPN in Ohio practices at the direction of an RN, physician, or other authorized practitioner. The LPN's role is focused on observation and implementation. They contribute to the assessment, but the RN must verify and finalize it.
I think the direction part is what trips people up. Does the RN have to be standing over the LPN's shoulder?
No, but the RN must be accessible and available. The LPN needs a clear director for their nursing actions. If an LPN is working in a home health setting, they need an RN who is reachable to supervise that care plan.
We should also mention the APRN. In Ohio, the law changed recently to grant more autonomy, but APRNs still practice within a specific standard care arrangement with a collaborating physician. If there's one thing that gets Ohio nurses in trouble more than anything else, it's delegation.
Absolutely. Under OAC 4713, the board has very strict rules on how you hand off a task to an unlicensed assistive personnel, like a tech or CNA.
I always tell people, you can delegate a task, but you can never delegate your accountability.
That is the golden rule. In Ohio, before you delegate, you have to verify 3 things. Is the task within your scope? Is the task predictable and stable? And is the person you are delegating to trained and competent?
So, can I delegate a dressing change on a fresh surgical wound?
Probably not. If that wound requires an assessment of the tissue, which involves nursing judgment, it cannot be delegated to a tech. You can delegate a bed bath, but you can't delegate the skin assessment that happens during that bath.
The board is very clear that if you delegate a task and the tech messes it up and you didn't follow the proper 5 rights of delegation, the board will look at your license, not just the tech's job. Let's talk about the blue wall of silence. In Ohio, that wall doesn't exist legally. We have mandatory reporting.
This is a heavy one. Under ORC 4734, every nurse has a legal duty to report. If you have knowledge that another nurse is impaired, diverting drugs, or abusing a patient, you are legally required to notify the board.
What happens if I don't report?
You can be disciplined for failing to report. The law views your silence as a violation of the public trust. The board provides good faith immunity, meaning that as long as you aren't reporting someone out of malice or lies, you're protected from civil lawsuits.
It's about the standard of care. The law requires us to practice according to acceptable and prevailing standards. If we see someone falling below that, we're the first line of defense for the patient.
And that standard isn't just a suggestion, it's a legal mandate. If you are a nurse in Cleveland, you're held to the same standard as a nurse in Cincinnati.
Finally, let's talk about the maintenance phase. You worked hard for that license. How do you keep it?
Ohio follows a 2-year renewal cycle. RNs renew in the on years, LPNs in the even years. You need 24 contact hours of continuing education.
But not just any 24 hours.
Right. At least 1 hour must be Category A. This is 1 hour specifically dedicated to the Ohio Nurse Practice Act and its rules. It's the state's way of ensuring you're keeping up with changes in the law.
And don't forget, you have to keep your records for 6 years in case the board audits you.
Exactly. As we close out, Mark, what's your final piece of advice for the Ohio nurse?
My advice is to bookmark the Board of Nursing website. Law changes, rules change. Staying current on your jurisprudence isn't just a requirement, it's the best malpractice insurance you can have.
Well said. The law isn't there to hinder you, it's there to provide the boundaries within which you can provide excellent, safe care.
Thanks for joining us for this deep dive into the Buckeye State's nursing laws.
Stay safe, stay legal, and keep practicing with excellence.